Talking crime and punishment, we were talking about before the show started about a few topics that we really want to kind of hit. And I believe one of them is just kind of, there's a lot of people out there just do not understand the process and the procedure that goes what happens when you get arrested. We've always heard, if you have a domestic issue, somebody's going to go away. It feels like somebody's always going to go away in cuffs. Why does that happen? If you've been arrested, what happens next? Are you just going to go to the jail and just be released? No, that's just the starting point of what is yet to come. And also get into some attorney fee talk, because I think if people will really think about how expensive it is to hire good, competent attorneys, if you're not going to be using the public defender's office, you're going to pay a big price for that. And there's some people that don't qualify for the public defender's help, and so they're going to have to spend the money, and they need to understand what those costs are like. But jumping into it real quickly, I guess on the go ahead and just jumping into this, I should say better, is let's talk about the procedures and the processes of what happens when you get arrested and what to expect.
Sure. So when you get arrested, I think a lot of people are surprised that people are out of custody so quickly when they're arrested. The other thing, too, I think a lot of times people are surprised that they're arrested at all, even for a minor offense. Right. So a lot of that is really within the officer's discretion, and some of it, when you mentioned domestic violence, some of it may not be, right? But when someone is arrested, they're taken to the jail. We have a law here in Florida, or a procedure here in Florida, that says that you have to be first appeared within the first 24 hours. So that's every 24 hours a judge is seeing the people who have been arrested and giving them terms of release. There are very few offenses in Florida where someone doesn't have the ability to be released. Murder being one of them, if they're a danger to the community, and that's actually a pretty high bar. Those are really the only time. Of course, if someone commits a subsequent offense or violates a bond that they're on, right, that can be a reason to hold them without too.
Now let me jump in. When
Sure.
you said get released, it's not, hey, slap you on your hands.
Oh no.
You're out. There's conditions of your release. Some people get released without having to put up a bond. Some people have to put up a bond, they have to put up properties just to be released from custody.
Right. So at that first appearance, the judge is addressing, your ties to the community, what you're charged with, your criminal history. Were you a fugitive from justice? In other words, did you turn yourself in? Those types of issues. And when they, and based upon those, the judge will come up with a bond, or sometimes it's something called pretrial release, which literally is someone getting out of jail without having to pay a bond. Many times that can be for a minor offense, or if someone doesn't have any criminal history and has great ties to the community. But in the terms of a monetary release, a bond, the judge would give that bond, and upon payment of that bond, then the person would be released.
So you're released from jail. The judge is going to either qualify you for, or you're going to qualify, and he's going to determine whether you qualify for a public defender or whether you don't. And if you don't, someone who represents himself has a fool for a client, so you better go find you an attorney. So Rusty, if someone were to come into your office, retain you, what is the next step? I know they have an arraignment, and then all of a sudden you get through discovery, pretrial. Explain some of that process.
Right. So, and first and foremost, Chris, if I may, I think a lot of people get confused. They say, well, this person was arrested. How come they're out? How can they possibly be out of jail? And again, this is America, and we have due process, and that means that you have a right to have the state prove the case, if they can, against you. And so what this is this is really a criminal case being launched. That first appearance ties you to a court date. It does not mean, hey, you spent a night in jail, you're free to go. So it's, realize that the person who's arrested is going to have to come back to court and actually stand and answer to the charges. And again, they have a right to have the state prove the charge against them. So to your point, what happens after they're released, or sometimes when they're not released, because even though there are bonds, some of those bonds, particularly in higher level felony offenses, can be massive. It is not entirely uncommon for some of those bonds to be in the hundreds of thousands of dollars, right? Mm-hmm. So a lot of times what will happen is they'll come to my office seeking, an attorney for the case. A lot of times what that is a consultation. You know, I personally have a thing where I don't like getting hired on cases where I haven't met with the person. I want to make sure that, you know, I'm good with them and that they're good with me, because really, Chris, and you know this, at the end of the day, when clients hire us, they're putting their future into our hands. So, you know, I think that it's a lot to really lay eyes on someone and talk to them face to face. But, you know, generally what I'll do is kind of talk to them about what they're charged with and effectively get their side of what happened. Talk to them about the offense, what the maximum is. Florida also has a scheme called a score sheet where they talk about lowest permissible sentences. And I think that it's really important that people are accurately informed on those things before they go any further.
Now, you know, when they go into the courtroom, they have an arraignment, which is a formal reading of the charges, so you
Correct.
actually know what you're getting charged with. Then you discuss it with your attorney, and then at that point, you kind of get really involved into discovery, trying to get information from the arresting officers or the agencies, anything you can to help, I guess, defend the case.
Right.
Because it's like you say, the state, they have a burden. They have to prosecute the case. They have to prove the case, and thank goodness in our country, everybody's innocent until proven guilty.
Unless proven guilty, right?
Oh.
I mean, that presumes the state can prove the charges. So, and you know, realize that's a very high burden that the state has. They have to prove it beyond and to the exclusion of every reasonable doubt. And that's a phrase that I think a lot of times people don't understand. But how I define it generally is by taking the standard that's just below it, which is clear and convincing evidence. You know, beyond it to the exclusion of every reasonable doubt is the highest burden in our justice system. The next one down is clear and convincing evidence. And you think about what a high burden that is, because you have to be more than clearly convinced. I mean, think of something that you're clearly convinced of, and it's a higher burden than that.
Right.
So, you know, the state has a lot of work to do, and, you know, many times, you know, what we're doing in my job is looking at the case. And, you know, obviously we want to make sure that the state has done a full, thorough, and unbiased investigation. Many times we come back and realize there's a whole lot more to do in a case than has been done prior to the arrest. And that's really our job, is to go back and look at those and, you know, if indeed they can prove it, look at mitigating factors, things like that.
Push pause on that comment